Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hi, welcome to our Men's Divorce Podcast. The purpose of this podcast is to educate you on some interesting family law topics that we have some more detailed insight on with our specialization in family law. We will not be providing legal advice today. If you do want to obtain some legal advice, we want to encourage you to set up a consultation with us. So to do so, you can call 1-866-DADS-LAW, or you can visit our website at cordellcordell.com. My name is Julianne Morgan. I am a management partner in our Dallas office. I have been with Cordell Cordell for about 12 and a half years, and I've always been practicing in the Dallas area. Joining me today is Elise Stremel, and I'm going to hand it over to her to give a brief introduction.
Hi, thank you, Julianne. My name is Elise Stremel. I'm a litigation manager here in the San Antonio office. I've been with Cordell Cordell for about 6 years now. I've been licensed in Texas since 2016, so about 8 years, and I'm happy to be here.
Great. Okay. So the topic that Elise and I are going to be discussing today is how to get ahead in a contested custody case. Which is something that we deal with on a day-to-day basis around here and is very common. So we're excited to kind of dive into some of the different tools, some of the different strategies, some of the different approaches that can be taken depending on the specific facts that we're going to be dealing with in each individual case. So I am going to hand it over to Elise to just kind of start in with some of the tools and resources that we can use.
Thank you. So as you kind of mentioned, in a contested family law case, in a custody case, for instance, there are certain tools and strategies that the Texas Family Code provides to get ahead in a custody case. And so there's kind of an overview that we're going to talk about today. There's a few things to mention. Number one, an amicus attorney. We can talk about that in a second. A custody evaluation, a psychological evaluation, and a motion to confer or conference with children. So those four topics are kind of what we're going to cover. The differences, the importances of each, and then strategy and tools to kind of wrap up the conversation.
Perfect. Okay, so let's start with the first topic that you had mentioned, an amicus attorney. So what is an amicus attorney? What role can they play? And potentially why would a client and their attorney look into potentially asking for one to be ordered?
So an amicus attorney is appointed on a case. Really, what stands out an amicus attorney from other tools to use is it is a third attorney that is appointed on a case to help the court identify what is in the best interest of the children. So they do not represent a party. They don't represent the children themselves. They represent to the court what the best interests of the children are. So they appear in hearings, they examine witnesses, they can assist the court in setting hearings, pushing a case forward. They can recommend settlement, they sign off on orders. So they really, truly are another attorney that comes in that assists the court in making that determination.
Right. And I think it's important to kind of note that, the point you made that they're there to educate the court about the best interest of the children. And so it's when the court is looking at a really contested custody case, they're going to be looking at a list of different factors, regardless of what state you're in, what jurisdiction you're in. The judge is going to be looking at a specific set of factors, and those combined together, they weigh the pros and cons and which parent is showing to be best fit for those different characteristics is how they're going to determine what is in the absolute best interest of the child or of the children in general. So it is the role of the amicus, like we said, not necessarily they're not representing one party per se to try to give that non-biased feedback to the court based on their interactions with them. In your experience, have amicus attorneys, can they be agreed upon by the parties? Do they always have to be court ordered? What are some of the different ways we can come about having them appointed or included in a case?
So they can either be agreed upon or they can be ordered by the court. So a party can file a motion to appoint an amicus attorney. If, for whatever reason, the other side does not agree to the appointment, then you present your side, your facts, your reasons in front of a judge, and the judge can, within its discretion, order the appointment of an amicus attorney if it determines that that's going to help the court make a determination as to the custody aspect.
Right. So I think, just following up on that, that's also a really important factor to keep in mind, that just because one party would like for an amicus attorney to be appointed, if the other party doesn't agree and the motion is presented and the attorneys make their arguments as to their separate positions, a court could say, under these circumstances and under these set of facts, I don't think an amicus attorney is going to be helpful, and that request could be denied. So in that event, if that happens, or even if that's not what happens, we have other tools, we have other resources we can use. So let's move on to our second topic and just kind of give a little bit of background about what a custody evaluation is. It could be called something a little bit different in different jurisdictions, but the general idea of the purpose and how they're utilized in these contested cases is pretty much the same.
Right. So a custody evaluation itself is, again, somebody appointed by the court to make a recommendation as to custody. They create a report. That report includes their opinions, their evaluations, their recommendation as to conservatorship, possession of children. So this is very much distinguishable from an amicus attorney because a custody evaluator is a testifying expert. They have to be licensed with like a psychology background, psychiatry background, a marriage or family counselor, somebody who has a very heavy psychology background. A social worker, for instance, would be another good one. And they create a report, like I stated, but they end up testifying in the case or can testify in the case as to their recommendation. So unlike an amicus attorney, this individual is actually a witness that will testify as to their opinions and their recommendations, whereas an amicus attorney is an attorney on the case that does not testify, and they do cross-examine or direct witnesses.
Right. And the process and I think kind of the role of the custody evaluator is also much more involved, I find, than typically the role that the amicus plays. So let's talk about just some different, what the custody evaluator looks at in terms of references, medical records, school reports, just kind of go into all of the different body of knowledge and conversations they can have to put together and kind of formulate that overall report and then make their recommendation. Right.
So like you stated, they do, of course, talk to the parties. Children 4 and older, they do speak to. They talk to counselors, talk to CPS. If they determine that there might be some type of medical issue or psychological issue, they can refer parties over to counseling. They do take into account any medical records or psychological records. Although they cannot rely wholly on just the medical record itself, they do take that into account in their report. So there's a heavy crossover, in my opinion, between a custody evaluation and a psychological evaluation. A lot of times you see they go hand in hand because they can be done by the same person, i.e. a psychologist on the case. And so there, like you stated, there is a heavy component into a psychological background and finding out what, again, is in the child's best interest, dependent on that person's specialty.
Sure. And I think it's also important for us to note that typically both parties share the cost of a custody evaluator. There are times when maybe one party may be ordered to pay the entire cost if it's a modification case, but usually if it's a divorce case, they share the expense, not always equally, but both parties, do partake in that. And then we get that report back. The judge is able to review it prior to a hearing, so they know what that recommendation is. But it's absolutely not a guarantee that the court's going to follow that recommendation. So if we were to think of times or examples of maybe why a court wouldn't, I think probably most likely it would be if the if it came back in our favor and then the opposing counsel puts the custody evaluator on the stand, sometimes they can really poke holes into that report. So I think kind of talking about the importance of just making sure that you are using a custody evaluator that has a lot of experience, who's done this many times, who's comfortable testifying, is really able to back up a lot of what they include in that report, and most importantly, back up why they made the recommendation they did, knowing that no matter what they recommend, it's almost guaranteed that one party is not going to agree with it.
Mm-hmm. That's actually a really good point. And so, of course, everybody, if they're going through a custody battle, does want to have that conversation with their attorney. What is the best tool for me? What is the strategy that we can use in appointing either one of these individuals on the case? But that a custody evaluator's opinion is going to be more subject to attack than would be an amicus attorney. Because like you just stated, they are going to be testifying. Their opinion is going to be up for determination. Their credibility can be attacked. What did they do and not do in the case? So that's a really good point you made.
Yeah. So like we said, it can be very helpful, especially if we're trying to resolve the case at mediation. A lot of times we'll wait to get the custody evaluator's report back prior to attending mediation so that we have a pretty good idea of, okay, well, if we go to court, this is what the judge is going to see, and this is why they made their recommendations. But, it's not always followed, so there can be reasons why you can go in and attack the report and try to get somewhat of a different outcome. So, I know you referenced the psychological evaluation, and this can be extremely helpful in custody cases if the judge also feels that they could be helpful. But kind of tell us a little bit about what they are and when we use them and how they're ordered.
So again, heavy crossover between custody evaluation, psychological evaluation. If in your case you want to kind of dig into the opposing party's psychiatric history, their psychological functioning, how that affects their ability to parent, their fitness as a parent, and how their psychological functioning affects their ability to operate on a day-to-day basis when it comes to their parenting skills. And so this is really helpful to peel back those layers that wouldn't be so obvious. Because at the outset, you might not see that there's an issue with somebody's psychological functioning until you really dig into, you have that person submit to psychological testing, their personality testing, and then you can kind of figure out, look, these are the red flags that we see with their functioning, and this is how it may or may not affect their parenting style.
Right. I think also important to note when your client, because sometimes this is very client driven, they can come in and say, he or she has shown a propensity to behave this way. She or he has a propensity to have anger management issues. They're disorganized. They're, all types of different, concerns that they can have. Important to have the conversation that if we're typically asking for the opposing party to undergo a psychological evaluation, they're most likely going to ask for our client to undergo a psychological evaluation. So with most conversations that we have throughout the course of a case of weighing our pros and cons, being mindful that a lot of these tools, when they come into play, typically can be mutual. It's not, you don't see it very often that only one party is ordered to take the psychological evaluation. Is that kind of been your experience with them?
Absolutely. I would say more likely than not, if you raise the issue of this person's psychological functioning is not intact, we've got issues regarding their ability to parent, a court will very likely order that it's going to be a mutual evaluation that both parties submit to. And you, of course, want to have that conversation with your client. Hey, what is your psychological background? Is there anything that we should know about your history? Anything that may come up, because not only is it their current functioning, but there's also a heavy component into history, background. How did you grow up? Where did you grow up? What is your family background? And all of that will become a part of the report and a part of the evaluator's evaluation itself.
Right, absolutely. And so moving to the report and the evaluation itself, is this something that is typically admitted into evidence? Is whoever conducts the psychological evaluation, could they be called as a testifying expert? What role can that report or the actual individual who conducts this play if we end up in the courtroom?
So in my experience, they've always been a testifying witness. The report has always come into evidence. It is, of course, a summarization of their findings. What did they do? Their opinions, the background. So expect that it will always come into evidence. And something to really consider is that if there is evidence that maybe would have normally been precluded in a case because of whatever reason, maybe it's going back before the marriage, maybe it's going behind a prior order in the case, it's actually very strategic to do a psychological evaluation because it comes into the history section of the report. And so things that might normally not be able to be admitted as evidence may sneak their way into a report, which would be admitted as an exhibit that a judge may consider in a case.
Right. That's a great point. Yeah. And these are kind of just some different tips from, having done this over and over and over again. You kind of pick up on some of those, and you can see other attorneys, how they're using the tools and kind of how they're able to get things into evidence. So yeah, that's a really, really good point. If you do know that there's something you're trying to get in, if you're in a jurisdiction like we are in Texas and you're looking to modify an order, and we're not able to admit evidence unless it falls into very limited exceptions, that of anything that occurred prior to the last order that was entered. So if you are trying to find a way to get it in, that would be one tool that you could try to go about getting that information in. So that's a great tip. Lastly, on the psychological evaluations, I think also important to note, although they can be court appointed, you can also agree to who you want to do the psychological evaluation. But similar to a custody evaluator, they're most likely going to find themselves on the stand. So you really, you want to do your research. You want to make it sure it's someone who has testified before, who's very comfortable referencing different parts of their report and has that experience in the courtroom. Would you agree?
Absolutely. Yes.
Yeah. And that comes into play with almost all experts that are used. But it's very important in custody cases because everyone can have their facts and everyone can have, these are the best interest factors. But the reality is a lot of these findings are subjective. And so, of course, we have the psychological evaluation that's still going to have opinions in it. The custody evaluation, it's going to have a lot of opinions in it. So you just want to make sure you have someone, whether they come down on your side or not, who's done hundreds of these, and they have enough experience that you're going to feel confident that whether or not you agree with whatever these findings are, that they really did their due diligence and they have the experience that we would want to be representing. So last but not least, in our jurisdiction, we have what's called a motion to confer, a conference with children. There may be a variation of this in other states and other jurisdictions, but it is a very useful tool. So kind of go into a little bit about what is the motion to confer and when we use them.
So a motion to confer would be a document filed into a case in conjunction with another hearing. And the purpose of a motion to confer or a conference with children is that a child age 12 or older would be able to speak directly to a judge about kind of what's going on, what's happening in their home, what's happening with a parent, what their preference is regarding who they want to live with primarily, how frequently they want to see a parent. And so important to note that age 12 or older, right? That seems to be a very distinct cutoff because at that point in time, if a proper motion to confer is filed with the court, a judge actually doesn't even have discretion at that point to determine whether they should or should not interview this child because it's mandatory. So 12 is that very hard and fast deadline. Anything younger than 12 is going to be discretionary. So whether a judge determines that this child is of sufficient maturity, other facts and circumstances surrounding why a child younger than 12 would be able to articulate themselves in a mature way. So we really look at that age. If it's 12 or older, we know absolutely if that could be a conversation that you have with your client. What do you think that your child is going to say about their preference? Do they want to live with you? And if so, we really want to strongly consider filing this motion, having your child speak with a judge so that their voice can be heard.
Right. And this can be a really tricky tool and conversation to have with your client because we do, as the statute's drafted here in Texas, and I think 12 is a pretty common age across other states, but there may be some that are a little younger and a little bit older. But we have to keep in mind there's also a very, very strong public policy and it even is in some standing orders that the parents are not to discuss the litigation with the children. So it can really backfire on clients if they've been having conversations with their 14-year-old about, so who do you want to live with? Even just asking your child that question is going to be frowned upon, because now you're already, in a lot of courts' eyes, you're trying to influence that. You're trying to sway them in one direction or the other. I think we all know from our past experience, most children want to please their parents, and they want to tell their parents what they know that parent wants to hear. So there have definitely been times that, clients have said, oh, I know they're going to say this. I know they're going to go and they're going to say they want to live with me and they want to, and then that doesn't always happen. Because I think also interesting, kind of go into the role that the judges play in these conversations, because they don't just, they're good at this, right? I mean, they know what they're doing. They know these kids are trying to not disparage either parent. So kind of go into that role and kind of how some of those conversations go.
Right. So I think what's important to note is that even if we have this conversation with the client, and even if, the client says, my child came to me, this is what my child has expressed to me, know that when this conversation occurs between the child and the judge, it may not go that way. Like what you had mentioned earlier, sometimes the child tells you, or your child says, this is what I'm saying to you because I think this is what you want to hear. I want to please my parents. I don't want to upset them. And so this is more of a dicey motion that you file, and you really truly need to do it if you are secure enough to know, or your client is secure enough to know that this may not go your way. This may backfire. And even if the child tells a judge, this is who I want to live with, that is a factor amongst many. It is not the be all end all. And so a judge can say or determine that although this child says they want to live with dad, here are other factors that I'm going to consider. And that is not going to be an automatic, this parent now has primary possession or primary custody of this child.
Right. Because it also can be somewhat of a red flag to judges if children come, because the majority of children say something positive about both parents. If a child comes in, and they might still have a preference, right? But if a child comes in and they are very adamant about really only wanting to be with one parent, the judge is going to start digging a little bit deeper, and they're going to start wondering why. And there could be, they might start thinking there's potentially parental alienation. Is there a reason why this child doesn't want to be around the other parent? Because, like I said, it's not unusual for a child to potentially have a preference, but it is somewhat unusual for a child to want to have absolutely nothing to do with another parent, or if it is extremely one-sided. And there can be very good reason for that, but it's not something that the court's going to just pass over. They're going to want to try to figure out a little bit more as to what's the dynamic, why is this going on? And so it's just, I think motions to confer are really helpful, and I think they're a really useful tool, but it's always, you're always dealing with someone of the unknown. And in this one, you're dealing with children, and children that you've specifically been told you're not supposed to discuss litigation with. And so you really can't and shouldn't be 100% confident about what's going to be said, knowing that we're really not supposed to have that conversation with them.
Right.
In your experience, have you, and this differs by court and jurisdiction, have you had judges, do you think it's more useful, and it probably is fact specific to a case, whether you file the motion to confer earlier in the case and have the judge talk to the child at like a temporary orders hearing, or file it later in the case and request that they talk to them at trial, or both?
That's a really good question. I would agree that it is very fact specific. It depends on what has happened leading up to that hearing. What has happened before this case itself has been filed? Where has the child been before this motion to confer has been filed? Because child could be with one parent for an extended period of time, and then once a motion to confer is filed, it's heard in front of a judge. Well, yeah, we expect that there might be a preference because of where this child has been for the X period leading up to the hearing. So what I would say is that in my experience and in cases that I've had, if a motion to confer has been filed, there typically is another tool that we've discussed that is incorporated into the case. So there might also be a psychological evaluation or an amicus attorney on the case, because a child has a tendency to want to be with a parent who maybe provides that child with the things the child wants, not necessarily things the child needs. And so it's really good to have a well-rounded case, because that can always be present. Is a parent disciplining their child? Is a parent not? Is a child staying up till 2 a.m. on their phone or on their tablet or watching TV? Yeah, they might want to be with that parent, but that doesn't mean that that's what's best for the child.
Right. No, that's perfect. I completely agree. So just because it's what the child's preference is, doesn't necessarily mean that that's what the court's going to do for all of the reasons that you just discussed. So it is really helpful to use this motion to confer in conjunction with some other tools. So, to kind of summarize what we went through, if you are in a situation where you think that you may be, or you already are, in some type of contested custody cases, these are just some really good tools, some good resources. There's many more out there. And like we said, some are going to be more specific to your jurisdiction. So, if you find yourself in a situation where you want to review these and get some legal advice on them, then we do just want to encourage you to set up a consultation with us. And you can do so by calling 1-866-DADS-LAW or visit our website at CordellCordell.com. And thank you so much, Elise, for your time today. This was great.
Thank you.